All right. Sorry for being a few minutes late, guys. I know I'm like 4 minutes late. Um, and every time that countdown happens, I'm like, oh shoot, I only have so much time. And then something happens, and I've got to like take care of it really quick, and then scramble back. Anyway, well, we are here now, and if you are here, you probably are aware that yesterday Marilyn Manson's replies to the oppositions to his motion to conduct limited discovery just were filed yesterday. So they just came in. We are going to do a first look at these and basically see what we can come up with. Are his arguments good? Is this essentially a clapback, or are his arguments basically unpersuasive? Let's take a look, shall we? All right. Let's get into it. Hello and welcome to Legal Bites. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legal Bites merch. Again, all links are in the description below. And with that said, let's get into it. All right, let's get into it indeed. Alrighty, so first off, good morning, good afternoon, good evening. Rattlesnake, good morning from Lawrence, Kansas? Kansas, right? KS is Kansas. I should know that. Yeah, because KN would be Kentucky, right? Okay. Anyway, we'll go with Kansas. Viv Photography from Florida. Hi. Wagner Warner from France. Good afternoon from France. We've got from Florida, Maddie and Josh Thompson. Hello. We've also got, let's see here, Laura Rosalind from Central Texas. Hi. Hello. How's it going? Raw Potato says Labas Vakaras. That means good evening in Lithuanian. Labutis, Raw Potato. That means hello. So I love it. Love seeing all these folks in the chat. We are going to get into some documents here. It's going to be good. It's going to be a good morning, afternoon / evening, wherever you are. So anyhow, if you have seen these documents so far, then you are probably one of the very few people, because these, like I said, were just filed. For a little bit of context before I dive in, these are, I've got it in the description below in case anybody is confused, but if you haven't seen the previous videos on the motions before, and you aren't familiar with this particular process, you might want to watch those live streams first. Of course, they are very long. I apologize for that, but we do go into depth. We read everything, soup to nuts. So you can see exactly what is in those filings, starting with the motion to conduct limited discovery, and then the oppositions that were filed by Evan Rachel Wood and Illma Gore. And then now we've got the replies, as I said. Basically, the main gist of it is Evan Rachel Wood and Illma Gore have filed anti-SLAPP motions, which means that they are trying to get certain portions of the complaint dismissed, basically saying that they are, without using the word vexatious, basically saying these are vexatious. It's improper litigation because it's just trying to stifle their constitutional rights, their constitutional rights to free speech and to petition the government, et cetera, et cetera. So that's the gist of the anti-SLAPP motions. And then, so what happens is the entire litigation process gets frozen as soon as an anti-SLAPP motion is filed. It's different in that respect from other types of motions to dismiss or to strike certain causes of action, because it's a very, very powerful motion in that respect. So in order for Brian Warner, aka, or PKA, professionally known as Marilyn Manson, in order for him to request information from them, he has to file a motion for it. They've got to argue back and forth, and then the court will make a determination. And basically, it has to be for very limited purposes. And specifically, it has to be only what he needs in order to respond to the anti-SLAPP motions. And he has to have good cause for it. In other words, if he's requesting information that he could get on his own otherwise, through talking to people and having them sign declarations, for example, or through his own records, through his own documents, through his own knowledge, and he can do a declaration, then that kind of information is not what the court is going to allow him to request discovery. On the other hand, if there's information that he can't reasonably get, except for by deposing third parties, by deposing other parties, the opposing parties, or by making documentary requests, things like that, that's more what the court is going to be looking at to say, okay, this is more likely to be good cause for the discovery. All right, 2012 Jameson, thanks for the super chat. Says they shot their shot. End of story. I'm not sure exactly what you mean by that specifically. Are you referring to the defendants in the case, or are you referring to the motions here? Not sure. Anyway, thanks for the super chat. Anyway, it's good to see you again. Okay, so with that, let's start. Okay, so here is, first off, we're going to do Marilyn Manson's reply addressing Evan Rachel Wood's opposition to his motion, right? So as I've said before, you've got this, when in motion practice, you've got a tennis match that happens, or a game of hot potato, however you want to look at it. So maybe visually like a tennis match where you've got someone files a motion, it pops over to the other side for them to make their case, and then it pops back over the net back to the person that filed the motion to file their reply. So motion, opposition, reply. And so they had to file it within 5 days of the filings of the oppositions. And so we are here. So this one is, as I said, this is specifically responding to Evan Rachel Wood's opposition. So we've got the basic outline of the arguments. We're going to skip right through that and cut right to the chase. Okay. Starting with the basic roadmap of this filing here. 3 dispositive flaws run throughout Evan Rachel Wood's opposition to Brian Warner's motion for limited specified discovery. The first is Wood's apparent belief that requesting discovery proves Warner's claims lack merit. But this cannot be true, as discovery is authorized by statute, and citing to the statute, and trial courts are admonished not to abort potentially meritorious claims due to a lack of discovery. Wood complains about sitting for a limited deposition now, but ignores she will still be subject to discovery even if she and Illma Gore prevail on their motions to strike, because Wood and Gore do not seek dismissal of all Warner's claims. Wood also overstates the narrow scope of the 5 depositions sought, which comprises 1, confirming a handful of facts through admissible evidence unavailable to Warner, and or 2, authenticating documents. Wood's suggestion that Warner seeks evidence to prove every element of every claim is baseless. Now, remember what I said before is that there are multiple lines of attack for these oppositions. The lines of attack here are going to be, number 1, they're not entitled to any discovery because they have no way of proving this case possibly. So they shouldn't be allowed to do this. It's just going to subject these defendants to the litigation process, which is improper to begin with because of they're just exercising their constitutional rights. So that's one argument that they can have and have used. Number 2, and the second effective argument is an alternative argument to say, okay, so Judge, Your Honor, if you do decide to allow discovery, what they're requesting here is way overbroad, and it should be cut down to way, way, way less than what they're requesting. So, but here, and so my basic point here is that with the oppositions, they of course are going to try to, when they're making their argument, they're going to make their argument that is as favorable to their case as possible. So their argument is going to be these discovery requests are super broad. This is improper. This is, they're just requesting way too much for what is proper for this particular stage. On the other hand, then Brian Warner's side is their goal is to make it look like, no, these are very narrowly focused. These are very limited. These are very particularized. We're not looking for the broad scope of everything that we can request later on when we are in our normal litigation practice after this stage. We'll be able to request all of this other information from them. Right now, we're keeping it very narrow. And so that's the argument that they're making here, is to say that they're keeping it super limited to just requesting information that, one, confirms a handful of facts through admissible evidence unavailable to Warner, and two, authenticating documents. So, and then the other part of it is that Warner's side is correctly stating that no plaintiff is expected to have all of their information before they file a claim. I mean, they didn't say that verbatim, but that's essentially what they're saying here, is to say that courts understand that there's no expectation that a plaintiff have all of the information if there is information that is reasonably not going to be in their possession in order to prove their case. The second defect arises from Wood's reliance on her vague, self-serving testimony that denies her participation in certain acts. A defendant's declaration denying that he or she engaged in the conduct alleged in the complaint does not foreclose the ability that a fact finder could later find that he or she did in fact engage in that conduct. Foreclosing an anti-SLAPP motion based upon one version of the facts would irrationally and unfairly disregard this possibility. Even assuming Wood is correct that the declaration extricates her from liability on the challenged claims, it does not. Gore offers no testimony at all. Wood fails to explain why none of the requested discovery is necessary and relevant to the same claims pleaded against Gore. And that's an interesting point here, is that neither side seems to argue why those same claims aren't applicable to Gore. Everything at the very least in Wood's argument is pretty much centered on the claims as against her. And at the same time, what they say at the beginning of this paragraph is basically what I said when we were reading through the opposition, is that, the fact that she says that she didn't do something doesn't necessarily mean that she didn't do something, right? And it doesn't necessarily mean that the plaintiff can't prove that she actually did something, right? You prove that through circumstantial evidence. You prove that through other opposing evidence that comes in to undercut, to say, if somebody says, I didn't run a red light, and then you say, okay, but I have this witness that was sitting at the intersection during that light exchange, and they saw the light turned red for you. So just because that person said that they didn't run a red light doesn't mean that they actually did not run a red light. So, and that's kind of the point here, to say that, hey, he can still, that doesn't necessarily mean that he cannot prove his case. Okay. The opposition's third critical flaw results from Wood's failure to apply the correct legal standard to Warner's prima facie case under the anti-SLAPP statute's second prong. Only causes of action lacking even minimal merit may be stricken. And in making that determination, the court does not weigh evidence or resolve conflicting factual claims. Instead, the court must accept as true all evidence favorable to the plaintiff and assess the defendant's evidence only to determine if it defeats the plaintiff's submission as a matter of law. The court also must not weigh the credibility of evidence in determining whether Warner can make a prima facie case. Throughout, the opposition Wood urges the court to violate these rules and commit error by discounting Warner's evidence and the inferences that can be drawn from them, and accepting Wood's interpretations of the same evidence instead. And now I got a question on this about what exactly is prima facie. What does it mean to state a prima facie case? Prima facie, it means basically like on its face. So in other words, it means that when a plaintiff is stating their prima facie case, they are making allegations that on their face, you are supposed to assume the truth of those allegations for the purpose of that specific analysis. So, as I've said before, when a plaintiff files a complaint and the court is analyzing it under a motion to dismiss, the court is going to assume the truth of the facts that are alleged in that complaint. They're not looking to see if it's reasonable for that story to be true or if a jury might possibly determine that that's correct or not correct. The court just says, look, I'm not even going to entertain whether these are true or false. We are assuming that they're true. Have you alleged all of the facts that are necessary to state a case that is plausible? So, as I've said before, with, for example, with intentional infliction of emotional distress, there are a number of elements of that claim that the plaintiff has to check every box by making allegations, factual allegations, that essentially that check that box. Now, what do I mean when I say elements? I've gotten some questions before about this. Elements are basically portions. They're the broken down pieces of the definition of that cause of action. So, intentional infliction of emotional distress, what does it mean? It means when the defendant has engaged in outrageous conduct that causes severe emotional distress in the plaintiff, and that the plaintiff, ends up suffering major harm to them as a result. So what you do is you take that definition, you break it down into all of its smaller pieces. That's what the elements are. You've got extreme and outrageous conduct by the defendant. You've got severe emotional distress by the plaintiff. You've got causation to show that the plaintiff has to show that the harm was actually caused by that outrageous conduct and not by something else. And then you've got damages. Okay. Anyway, so when we're talking about a prima facie case, we're talking about a case that is stated by the plaintiff that the court is not going to analyze, like weighing whether or not those allegations could possibly be true. And that's exactly what they're saying here. Is they're saying that Evan Rachel Wood is basically trying to convince the court to weigh the evidence against each other, to say, well, Evan Rachel Wood says that this didn't happen, so therefore, her evidence is better than his, right? Like he says that the FBI letter is fake, and that she created it along with Illma Gore, and he has produced the declaration by Brighton Gore, for example, to say that she saw them, or she saw that the text message correspondences between the two talking about creating the letter. She overheard the conversation between them talking about the creation of that letter. And then she also saw other stuff like checklists, et cetera, et cetera. So, he has stated certain pieces of evidence that he says support his case. And so Evan Rachel Wood is trying to say, well, no, I denied that, so therefore he can't possibly prove it, which is not exactly a winning argument for this stage of litigation. So, 2012 Jameson. Oh, anti-SLAPP is now just standard of practice. And you said that, and also thanks for the super chats. And he said judges at anti-SLAPP are not supposed to weigh evidence because that is the juror's job. Exactly. Because the whole idea of weighing evidence is it's making a distinction between the trier of fact and the trier of law. So you've got the judge and the jury. The judge is always the trier of law. The jury is always the trier of fact. When we're talking about weighing evidence against each other, weighing the facts against each other, then we've got that is what goes to the jury. If you watched the Depp v. Heard case, for example, you probably, if you watched a gavel to gavel with us, you probably saw the various points in time where the two sides were trying to get the other side's claims dismissed. And so they made their arguments, and And basically, like, you know, when they were defending against the other side, trying to get their claims dismissed, they would be like, no, 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 no. All we need is a scintilla of evidence. All we need is a chinchilla of evidence. And so the court, if there was just a tiny little sliver of something, would say, I'm not going to take this away from the jury. That's because judges traditionally don't like taking those decisions away from a jury if there is any possibility at all that they can possibly find in the favor of the side whose claim would be getting dismissed. So exactly right. It's the job of the jurors to weigh the evidence. So if there's any, like I said before, I've said this in the last couple live streams, if there's any gray area, if there's any muddy middle right now, that is going to go in the favor of the plaintiff to allow these claims to continue through the litigation, because any sort of gray area means that it's up to interpretation. It could be found one way or another. Judges don't like making those decisions. They like taking those to the jury. So they don't want to take those away from a jury, which means that they don't want to dismiss them before a jury has a chance to evaluate all the evidence and make their decision on their own, aka at trial. Okay. Anyhow, and also there was another question here. From Misty says, do ERW and IG have the same lawyer? They do not. They are represented by two different firms. And in fact, in a case like this, I mean, there could be possible professional responsibility issues with both of them being represented by the same attorney, because you have a situation where they could end up pointing fingers at each other. And there could be confidences that they need to give to their attorneys. So when you have an attorney that's representing more than one client in one particular matter, typically they're supposed to have them sign a conflict waiver, but oftentimes that includes a conversation to say, hey, you know, what the other person tells me in a confidential meeting, I have to be able to tell the other party that I'm also representing for the purposes of this litigation. It's not confidential as against the other. So anyway, but yeah, that's not the case in this case, because they're entirely different firms. Evan Rachel Wood's firm is, I think, in Los Angeles. Yeah. Yes. No, hers is in Santa Monica, and Illma Gore's is in San Francisco. That's where they're located. Alrighty. Okay. And now back to this. Okay. Part 1. The good cause standard is not actually in dispute. Wood's opposition proceeds from the specious argument that by asking for discovery, Warner has somehow admitted his claims should be dismissed. To the contrary, Section 425.16 expressly authorizes that the court, on notice motion and for good cause shown, may order that specified discovery be conducted, notwithstanding the automatic discovery stay set forth in this subdivision. The availability of specified discovery is critical to a plaintiff's due process rights given the automatic stay. While a plaintiff may be required to make a prima facie showing on challenged claims, for certain claims, the defendant or third parties will generally be the principal, if not the only source of evidence. Thus, a court exercising its discretion to grant or deny a motion under Section 425.16 subdivision G should remain mindful that the anti-SLAPP statute was adopted to end meritless suits targeting protected speech, not to abort potentially meritorious claims due to a lack of discovery. Now, remember, like, keep in mind here that what they're saying here, this last sentence right here, is not to abort potentially meritorious claims. So it's not a requirement for Marilyn Manson to show here that his claims are meritorious. He has to just show that they are potentially meritorious, because it's if you think about it, it's putting too much of a burden on a plaintiff who could have very legitimate claims to say that, like, you all of a sudden in this kind of case, you now are not allowed to do discovery on the other side. And so therefore your claims will just never be heard, like, ever at all in this type of case. So basically, yes, this is a, I'm right on with, his attorneys here so far with this particular argument. And also Shireen Robson, is this normal back and forth? Yes. Yep. This is the typical, typical back and forth of motion practice where there'll be shade thrown at each other. There'll be, like, oh, this person misstates the law. This person misstated my argument, or, and it's just like, and most attorneys are not going to take that personally. I would say the vast majority of attorneys are not going to take it personally because it's just both sides are going to try to make their best argument. The only times when sometimes it's so subtle, but like sometimes you can find some shade here, which right here, this paragraph right here is an example where you have this right here, sick, SIC. It basically that's inserted where the attorney that is quoting the other side is saying sick means that there's an error in here that's in the original. So it's basically like it always, like, every time I've used sick to quote the other side and to, like, you're pointing out their error to the court to say this is not me, this is their error, this, like, their drafting error, whatever. It always feels so passive aggressive. But that's just me. I don't know if there are any other lawyers in the chat that have been in this kind of motion practice that have felt the same way. I know I saw Kurt in the chat. And then also 2012 Jameson, I know he's an attorney. So yeah, I don't know. Anyway, but that's just me. Let's continue. That said, Wood does not dispute that to demonstrate good cause for section 425.16G discovery, Warner must only, 1, explain what additional facts he expects to uncover through narrowly tailored discovery. 2, explain why those facts are necessary to carry his burden in opposing the anti-SLAPP motion. 3, show his claims are legally sufficient. And 3, sick. In other words, what they're saying is it's supposed to be 4. Demonstrate that he can make a prima facie showing on all other essential elements of his claims. Warner satisfies each prerequisite. All right. 2, nothing in Wood's opposition forecloses discovery. Basically, none of her arguments are good enough to say that discovery shouldn't happen. A, depositions are narrowly tailored and responsive, or the depositions here are narrowly tailored and responsive to section 425.16 motions. Limited discovery Warner seeks, remember, their job is to characterize this discovery as limited as possible. The limited discovery Warner seeks, 2 party and 3 non-party depositions, but no document requests or written discovery, are narrowly tailored and responsive to Woods and Gore's motions. They're like, look, we could have requested all of this other stuff. We could have requested documents. We could have, they could also flesh this out and be like, we're not requesting any interrogatories. We're not requesting any like requests for admissions. These are different types of discovery requests that can be made in litigation. They could like point this out to be like, hey, these are all of the kinds of discovery that we're not requesting. We're only requesting discovery. But anyway, they just limited that to pointing out that they're not requesting any documents from them. Wood's opposition does not dispute that 1, Warner explained what additional facts he expects to uncover. 2, each, and then this is smart. This is smart right here, how they are citing exactly to his motion where it is that they say that he made these arguments. So to clarify, these 4 or 5 points that are being highlighted here, these are the requirements for him to be able to request discovery. This is under California law. So these are elements of a claim for limited discovery under anti-SLAPP, you could say. So okay. So anyway, Wood's opposition does not dispute that 1, Warner explained what additional facts he expects to uncover in the discovery. 2, for each fact and deposition, Warner identified the claim element it supports. 3, for each claim element, Warner identified where in Woods and Gore's briefs it is raised. 4, the identified facts do not extend beyond the elements of his prima facie case. And 5, the facts Warner seeks through his section 425.16G request are not otherwise available to him. And like I said before, if you guys watched the live stream with me about his initial motion on this particular issue, one of the things that I pointed out at the end was how great it was that they included a very simple, easy to follow chart where they showed exactly what it was that they were requesting, who they were requesting it of, what claim it fell under, what element of the claim it fell under, and like the purpose of it. And just basically like they laid it out very specifically in that chart as dummy proof as possible, making it so that it's not requiring the judge or really anyone else to like sit there and interpret to be like, wait, what is this for? I don't understand. Well, maybe this is overbroad. No one's going to be, well, the opposing side, Evan Rachel Wood and Illma Gore are trying to make that argument here. But by having it so outlined in that chart that they included in their initial motion, they made it a lot easier to make this particular argument because they can just say, hey, check out that appendix, yo. It's that chart that we included. It's super easy to follow and you can see exactly where this stuff comes from. Wood argues the requested depositions are unprecedented, excuse me, unprecedented, unbounded, and extensive. But Wood cannot cite any authority supporting her assertion that 5 depositions versus a smaller number are improper. And then it cites Takanta Bala v. Hall, which says depositions of Hall, Siegel, and a handful of others was narrowly tailored. So they're giving an example right here to appellate case law, basically saying, hey, look, there was a handful plus the 2 defendants, I'm presumably the 2 defendants, and that was okay. So the fact that there's 5 that are being requested here is not crazy. The California case law has supported that number of depositions for anti-SLAPP discovery like this. In fact, she contends elsewhere that discovery should be denied because Warner has not asked for enough depositions. She kind of did make that argument at one point, didn't she? There is no basis for Wood to claim the depositions are unbounded or extensive either. Appendix A to Warner's motion, 3rd column, sets forth the bounds of the depositions and shows Warner was judicious in identifying the requested scope. Given there are 2 defendants moving to strike at least 4 portions of 2 causes of action based on challenges to at least 8 claim elements on the grounds Warner cannot make a prima facie showing, the handful or fewer of topics identified for each deposition is hardly unreasonable or excessive. Indeed, several of the topics relate solely to authenticating evidence disputed by Wood and Gore, and all of the witnesses can cure potential admissibility issues. And then where did this footnote come from? Okay, I'll get to that later. Notwithstanding the discovery stay, the court has discretion to order upon good cause specified discovery if required to overcome the hurdle of potential inadmissibility. Wood ignores that Gore's deposition covers the majority of facts sought, necessitated in part by Gore's lack of sworn testimony. Wood also ignores that all 3 of the non-party witnesses would not give declarations voluntarily, and thus the only way for Warner to obtain their testimony now is by deposition. Plaintiff knew which reporters had the information he needed and could have sought declarations from them. To the extent the reporters were uncooperative, plaintiff could have requested limited discovery. And so this is citing to the Sanchez v. Bazos case. It basically where the court has said, California appellate court has said before that, if they've got a third party that has information that they need, if they're not willingly participating, that's a good reason. That's a good reason to allow for discovery because that is information that is reasonably certain to apply to this for the specific purpose of responding to the anti-SLAPP motion. And if they're not willing to do so voluntarily, they can be compelled through a subpoena, which would be the discovery process. Okay, so what was this? Okay, contrary to Wood's repeated suggestion, no fact identified by Warner is sought to test her problematic declaration. That will come later. As Wood acknowledges several times, the 6 items for her deposition are extremely narrow. Okay, and then what is this other first footnote that I totally missed earlier? Okay, nothing is amiss, citing Lafayette Morehouse Inc. v. Chronicle Publishing Company. Appellate decisions, including those cited by Wood, have adopted the dictum in Lafayette. So dictum is where the court goes on and explains something that's not really necessary for the conclusion of what it is that they're there to decide. It's basically like you can think of dictum as like vestigial language, so to speak, where it's like they don't necessarily need to go through explaining something. They kind of go extra to explain some stuff. And so it's the court can other courts can end up like using that. Anyway, and then it cites to garment workers, which says, we are in general agreement, however, with the Lafayette Court's analysis of good cause for lifting the ban on discovery while a SLAPP motion is pending. And then see also Baya, which says, recent decisions cited by Warner affirming grant of discovery, citing Lafayette. The one case Wood cites supposedly limiting the reach of Lafayette denied discovery, not because the court rejected Lafayette, but because, unlike here, the plaintiff failed to demonstrate provably false facts. Okay, so basically, I think this is referring to what Wood was saying before. Remember, if you were there for the last live stream, talking about the oppositions, where I said, one effective way of motion practice is to take the legal support that the opposing side is using to support their arguments and to say, actually, like Krav Maga, right? Use it against them. To say, like, actually, that doesn't support their case, that supports our case. And so this is basically addressing that to say, actually, no, it doesn't support your case. It's fine. So yeah. Okay. Alrighty. Part B. Okay, let me get a couple super chats first. Okay. Tracy Fagan, thanks so much for your super chat. Says, I thought we had the right to redress our grievances, which includes a right to file a suit. Does that make anti-SLAPP unconstitutional? No. So anti-SLAPP, so when we're talking about the power of an anti-SLAPP motion, technically it is supposed to be used, and this is all in the case law that talks about anti-SLAPP laws, and so this is what's going to be argued by Marilyn Manson when he does eventually file his opposition to the anti-SLAPP motions that have been filed here. Because like I said before, we're like kind of in inception here, right? We're in like motion practice inception. The anti-SLAPP motions have been filed, and so he has to file his opposition to those motions. But in order for him to do that, he says he needs to be able to request some information. So we're down here trying to figure out if the court will allow him to request more information so that he can file his oppositions, and then the court can decide on the anti-SLAPP motions. So basically, he hasn't filed his oppositions yet. But I anticipate that his argument is going to be, because he's basically said as much in his discovery motion, saying that the anti-SLAPP law is supposed to prevent litigation that is improper because it's only trying to punish someone for using their constitutional rights. Constitutional rights, particularly talking about the First Amendment. So when we're talking about defamation, when we're talking about intentional infliction of emotional distress, sometimes there are certain aspects of that are merely expressive. And especially when we are talking about public figures, you can say all kinds of things about public figures. And it can be an expression of society or societal norms or something like that. Or maybe you're just trying to be an a-hole and you're trying to cause them emotional distress. But where that conduct is more about expression, it's more artistic, it's more, it has these messages that you are trying to make about life or society or yourself or what have you, then we are in constitutional territory, which is protected by anti-SLAPP. But other litigation that is, where there could be some anti-SLAPP, or there could be some constitutional issues there that are being discussed, but the plaintiff can still prove that what the person was doing was actually just trying to cause them emotional harm, or actually trying to defame them, then they have to be able to show that they have a probability of proving their causes of action. So that's exactly what Marilyn Manson has to do in opposition to the motion. So anti-SLAPP is not unconstitutional. In fact, it's trying to protect legitimate constitutional rights, where someone is just like, look, this guy just filed a defamation case against me because I wrote an article about him that was perfectly sourced from sources or what have you, that I talked to, and I can reasonably rely on them. So this is just me reporting the news. You know what I mean? And so, yeah. So anyway, I could go on and on and on, but I hope that makes sense to you. Nicholas Starrow, unionist labor law, says, I find myself surprisingly neutral so far in this. Yeah. Yeah, me too. And thanks so much for the super chat too. But also, yeah, it's interesting, right? Because I've said this before and I'll say it again. I grew up being somewhat terrified of Marilyn Manson. So I was definitely never in his core demographic of listeners or fans. And so yeah, he his whole aesthetic was intended to make people uncomfortable, and I think it had the desired effect on me. But I've said before, I'm pretty basic. I'm your pumpkin spice latte drinking, UGG wearing, legging wearing, basic basic biatch that loves puppies and kittens. But it's good. I mean, this is the way to be going into the case. So, but and I should have said this before, I've been meaning to say this in every live stream, that as we go along in this particular case, and in all of the cases that we go through, you start to encounter facts, you start to analyze the law, you apply the facts to the law, and you start to formulate an opinion. It's not the same thing as being biased. It is just analyzing and coming to your own decisions through your critical thinking. So there's absolutely nothing wrong with your opinion being changed over time. The more you dig into a case, the more you look at it, the more you evaluate the facts and analyze the law. And so I fully expect that at some point my needle is going to be moved one way or another over time. And it could also change in multiple directions, right? Because you encounter some evidence that looks damning for one side, and then evidence that's maybe damning for the other side. And so that you can have a little bit of a tennis match as you are going through and evaluating. So anyhow, that's my thought on that. 2012 Jameson, thanks for another super chat. Says dictum is just like college students trying to reach a word count limit. LOL. Yeah, essentially, if you've got someone who, I mean, I always had the opposite problem where I had to narrow my number of words to like meet just below the maximum word count, because I can go on when I write. And maybe that doesn't surprise people after watching my live streams when I go off in various directions. But, of course, there are folks that were not particularly verbose in their writing, and so needed to sort of add some filler to reach a word count limit. 2012 Jameson, also, thanks for another super chat, says BOR protects us from the government, not each other, the Bill of Rights. That is correct. However, when it comes to, anti-SLAPP litigation, the point, the reasoning behind it, I think, is where courts basically say, well, if I'm going to enforce this liability against the defendant, and the only reason for enforcing that liability really is because of this constitutional activity, or activity that is protected by the Constitution, then it's kind of like the government is enforcing that, which means the government is getting involved, and is therefore playing a role in abridging someone's constitutional rights. That's not necessarily exactly like what is the case everywhere, because in order for courts to have an anti-SLAPP mechanism. They have to have legislation in the state, and it's different from state to state, as people will know if they follow the Deputy Heard trial and are now following this one. Britt Cormier, thanks so much for your super chat. Says, I have no opinion on this one at all. I have not looked into the facts on either side. Not like the AH case. I knew she was crazy from the start. Yeah, that's like a lot of people. It's like a lot of people. So, all right, let's get back to it. Okay. Part B, there's good cause for limited discovery about the fake FBI letter. 1, the litigation privilege does not bar Warner's claim. All right. Why does it not bar the claim? As explained in the motion at pages 14 to 16, Wood cannot seek dismissal of Warner's claim based on her mischaracterization of it. And then it cites to Burrell v. Schnitt, which says allegations of protected activity that merely provide context without supporting a claim for recovery cannot be stricken under the anti-SLAPP statute. Yep. The complaint unmistakably alleges that Warner's claim arises from forging the fake FBI letter and using the letter and made-up investigation to recruit potential accusers, not filing the fake letter and a perjured declaration in Wood's custody proceeding. Wood fails to address the plain language of the complaint drawing this distinction and instead just reasserts that she and Gore should be excused from illegally impersonating an FBI agent because Wood also filed the letter in her parentage action. But Wood's own cited authority does not bear this out. Ooh, okay. For example, so in other words, what they're saying here is that his claim arises from forging the fake FBI letter and then using the letter and the made-up investigation to recruit potential accusers. So what I said before, it was being used as a recruitment tool according to the complaint. He's saying the other stuff about the custody matter, that was just used for context. So, and they cited to this case law that says when it's used merely as context, stuff like the parentage action, the custody action, that's not a reason to remove that claim that is actually about the use of the letter, the creation of the letter and the use of the letter in the conspiracy aspect. For example, so Wood's own cited authority does not bear this out. For example, in Pettit v. Levy, defendants altered plaintiffs' building permits and then submitted the forged permits to the city of Fresno for review so that the city would deny plaintiffs' requested zoning variance. The court found that the act of forgery had a sufficient relationship to an official proceeding, but only because the only acts alleged to have been done pursuant to the conspiracy are the preparation and submission of a false or forged building permit to the city of Fresno. And then it quotes it. It says, "We emphasize," this is from that other case. "We emphasize that the amended complaint herein does not allege, nor have appellants contended that any stage of this case that there was any publication or use of the false or forged permit other than in connection with the proceedings before the Fresno City Planning Commission and City Council. Nor do they allege that any damage resulted other than by the denial of a zoning variance to them by reason of its use before those bodies. Our decision herein is necessarily limited to those alleged facts." All right. And so they say, so here is where they're going to distinguish from that particular case. Warner's complaint does not only reference Wood's custody proceeding. This is true. He also alleges Wood and Gore intended to use the fake FBI letter and made up FBI investigation as one of many tactics to recruit, coordinate, and pressure false accusers. Citing to the complaint where it says Woods and Gore's wrongful conduct in furtherance of their conspiracy is staggering, including impersonating an actual agent of the Federal Bureau of Investigation by forging and distributing a fictitious letter from the agent. The forged letter would be used to recruit, encourage, and convince people to claim they were abused by Warner because they were led to believe that Warner was a threat to their safety and under federal investigation. The litigation privilege is not a cure-all for their troubling conduct. And then it cites to the Burke Declaration, which says ongoing investigation, quote unquote, by FBI and U.S. Attorney's Office, given Agent Langer did not write, letter, or investigate Wood or Warner. Yeah, no, this is absolutely correct. That just because something was used in litigation, it doesn't necessarily mean that they're able to use that same document everywhere and not get liability for it, right? So just because an example of that is just because the um legal arguments that were made by Adam Waldman in court for the Sun trial, the arguments that he made about the conspiracy, spilling wine and roughing up the place and all that kind of stuff, those statements that were that the very specific one that was deemed defamatory by the Fairfax jury, um, those are arguments that were made in court on Johnny Depp's behalf, right? So that making those arguments in court puts those under the litigation privilege. But if you make those same statements elsewhere, out of court and not in the context of the litigation, then yeah, it doesn't immunize you from saying the same thing in a million different places. Andy the Game Maker, hey brother, thanks for your super chat. Says, are you wearing your breakup sweater for this live stream like Monica from Silicon Valley? I don't know that I've seen enough of Silicon Valley to know what Monica's breakup sweater was, but I have not broken up with Mr. Bites. You will be happy to know your brother-in-law is still safe in our lives. And in fact, he bought me this sweater on our honeymoon. But thanks for the super chat. And 2012 Jameson, thanks for your super chat too, says the intended purpose was not for litigation. That is, yes, that's another part of that. Okay. Okay, part 2. Oops, that one. There we go. Aw, Secret McSquirrel. I really like that sweater. Thank you. I appreciate that. I like it too. That's why I wear it all the time. Okay, part 2. Wood argues that Warner cannot make a prima facie showing by improperly weighing evidence. Okay, putting aside. Ooh, wait a minute. Hang on. I missed another. I missed another footnote here. Andy the Game Maker. If Mr. Bites leaves, I will be devastated. I know you will. I know. You love him almost as much as I do. Okay. Footnote 3 here. So this was from the Burke Declaration talking about the conversation that she had with the FBI agent, right? Okay. Gore's undisputed participation and involvement at the same time she was recruiting prospective accusers belie Wood's claim that the letter was destined only for Wood's custody proceeding. So too does Wood's statement that the letter was important to her work against Warner, and news of its falsity would undermine her and other accusers' allegations. These are actually very good points. I mean, she does actually say that was I guess it was yeah, I guess that was in Brighton Gore's declaration, but she had said that the use of the letter was important in her work against Warner. And okay. And the fact that Illma Gore had it also, like, was she involved? Did she even know Evan Rachel Wood at the time of the custody proceeding? That's a very good point there to say, like, if she wasn't even around, or I guess she was, right? But anyway, but like, you know, what would Illma Gore have to do with the custody battle, right? Because that's between Evan Rachel Wood and Jamie Bell, has nothing to do with the Phoenix Act. That's strictly a personal matter, right? There was no DV that was alleged there. So what would that have to do with that? If it was not being used anywhere outside of that litigation. Wood's declaration does not and cannot negate Warner's evidence as a matter of law. There is more than sufficient evidence to proceed past anti-SLAPP and let the jury decide whether the fake letter was only intended for and used in the custody case. Yep. Yep. Citing to the King Declaration, fake FBI letter with Gore's name on it. Brighton Gore's declaration, Exhibit A, showing messages between Wood and Gore exchanging language for the fake FBI letter. And paragraph 6, conversation between Gore and Wood about FBI letter. And then the King Declaration, Exhibit D, referencing FBI to prospective accusers. Yeah, that's it's true. I mean, if you're looking at these different data points and saying, well, I don't know, maybe one is more likely than the other, you're talking about a jury question, which means that it's not to be dismissed before it goes to trial. If we are making arguments that are strictly weighing these data points against one another about likelihoods, possibilities, probabilities, things like that. Okay. Sorry. Now we're at part 2. Wood argues that Warner cannot make a prima facie showing by improperly weighing evidence, putting aside claim elements that either 1 are not disputed or 2 for which Warner seeks discovery. Wood fails to show that Warner has not made and cannot make a prima facie showing. She argues Warner has not alleged the required causal nexus between the alleged outrageous conduct and his purported distress. But this is set forth in his declaration. Wood offers no authority allowing the court to discredit, let alone ignore, Warner's declaration, nor can she, citing to Comstock, which says courts must accept as true all evidence favorable to the plaintiff. Right, because like I said before, any gray areas, any muddy middles at this stage in the litigation go to benefit the plaintiff. Wood's own carefully drafted declaration claiming she did not fabricate or forge the FBI letter and believed it to be authentic when she received a copy and submitted it to the court, whatever this all actually means, does not defeat Warner's prima facie case. At most, it creates a factual dispute, which at this stage must be resolved in Warner's favor. That's true. Wood does not deny she participated in drafting the letter, nor does she dispute the letter was created by someone other than its purported signatory, FBI Special Agent Michelle Langer. Neither Wood nor Gore address the incontrovertible fact that the FBI letter is a fake. Now, when they say that Wood did not deny that she participated in drafting the letter or dispute that it was created by someone else, I think she does, or at least her attorneys do in the opposition and in the initial anti-SLAPP motion. They do, but now that I'm thinking about it, I don't know if she says that in her declaration. That is supposed to be her words under penalty of perjury, right? Because the motions, the oppositions, like these memorandum of points and authority that we're going through right now that cite to all kinds of different things. This is all like her lawyers putting this together, right? But the declarations are the parts that are also realistically drafted by the attorneys on all sides, but they are drafted by the attorneys and then sent to the party who is supposed to be signing it. And then saying like, do you approve of this? If so, sign it. Is everything true and correct and blah, 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 blah. So this is all, like I said, under penalty of perjury, for those declarations specifically. So I don't remember if she said in her declaration, if she denied these things. Nor do they dispute Gore's involvement in the forgery, aside from encouraging the court to err by weighing certain evidence. Wood attempts to characterize some evidence that establishes Wood collaborated with Gore on the fake letter, while ignoring other evidence of the same thing. She also ignores evidence that multiple people told her the letter was inauthentic, but did nothing about it. Regardless, even if the claim survived against only Gore, with or without Wood being vicariously liable for Gore's conduct, the requested discovery is still plainly relevant. Well, that is true. I mean, as far as, oh, I think that was my phone. Okay. Yep. So, sorry about that, guys. If that was very loud, I apologize. Anyway, so what I said before was the claims about defamation against Evan Rachel Wood for the groupie video. They don't, to me, seem like very strong arguments to put those against Evan Rachel Wood, right? Because all of the allegations are basically put against Illma Gore. She's the one that said, the actress was underage, the actress is also dead, and, et cetera, et cetera. And then basically the allegation is that, Evan Rachel Wood like consented to and agreed to those statements, which to my mind is not enough for defamation, particularly against, like, especially against a public figure. But this is a good point to say he still is entitled to discovery on those, even if it's not likely to come about that Evan Rachel Wood is going to be kept as a defendant for that particular cause of action. That cause of action, that doesn't mean that cause of action is going to go away entirely. In other words, he still is able to request discovery, even if it's just against Illma Gore. Okay. Part 3. It makes little sense to preclude discovery when Warner will defeat Wood's motion on prong 1. While the requested discovery goes to Warner's prima facie showing to defeat Wood's motion under the anti-SLAPP analysis's second prong, the court will not get there, as Wood's motion fails under the first prong. Basically, what they're saying here is all of our discussion has been, there's the anti-SLAPP 2-part test that we've talked about before, so I won't get into those details. But basically, they're saying, look, we've been fighting about the second prong. We're going to win on the second prong, but you know what? We're not even going to get to the second prong because we're going to win on the first prong. So here's why. Under the anti-SLAPP framework, if a defendant fails to make a threshold showing that the causes of action arose from protected activity, there is no need to address the second step. And this footnote 4 here says, Warner does not seek discovery on the first anti-SLAPP prong. Wood's opposition. Facts Warner seeks on prong 2 also show Wood fails under the prong 1. Okay. Sure. Good point. Okay. Illegal activity is not a constitutionally protected exercise of the right of petition or free speech. Okay. Now here we get into the fight about what Evan Rachel Wood's, I think probably one of her stronger arguments was in her opposition, was that she was saying that the standard here is that the underlying conduct that is giving rise to this liability. There's this idea that anti-SLAPP is not going to protect a defendant if their underlying conduct was criminal, right? Because no one has a constitutional right to violate the law, right? To engage in criminal activity. You don't have it's completely inapposite. So what she's saying is that the standard is like, it's a very, very narrow exception to say that that the conduct would be criminal and that doesn't apply to this case. So she's saying that that her conduct still falls under constitutionally protected stuff. It doesn't get taken out by this narrow exception for criminal activity. Okay. Flatley v. Morrow sets forth the standard for establishing illegality in this context, but Wood misstates the actual rule. Okay, here we go. Where a defendant brings a motion to strike based on a claim that the plaintiff's action arises from activity by the defendant in furtherance of the defendant's exercise of protected speech or petition, of protected speech or petition rights, but either the defendant concedes or the evidence conclusively establishes that the assertedly protected speech or petition activity was illegal as a matter of law, the defendant is precluded from using the anti-SLAPP statute to strike the plaintiff's action. Thus, to show illegality, Warner does not need to conclusively prove that Wood forged the letter or knew it to be forged when she filed it. He needs to show only that the claimed protected activity is illegal as a matter of law, either because the evidence conclusively establishes or the defendant concedes illegality. And then he cites to Gerbosi v. Games Weil W. and Epstein LLP. Defendant's argument that its evidence showed it did not do the acts the plaintiff alleges it did is more suited to the second step of an anti-SLAPP motion. A showing that a defendant did not do an alleged activity is not a showing that the alleged activity is a protected activity. Okay. Warner meets this test. The FBI letter is undisputedly fraudulent, and its forging is conclusively illegal. There is no dispute Agent Langer did not write, sign, or authorize the letter, even though it purports she did. Neither Wood nor Gore seriously contend that forging the letter and impersonating Agent Langer is not a criminal act. Gore says nothing about it, and Wood, for her part, only tries to downplay the lack of an intent to defraud or deceive element in 18 U.S. Code Section 912 by claiming she could not have had the required mens rea. But mens rea in Section 912 requires only the defendant's knowledge that she is not truly an officer or employee of the United States, which Wood, for obvious reasons, does not dispute. In other words, they're saying that, so one of Wood's arguments was to say, look, for this to be conclusively criminal, Evan Rachel Wood would have to have the mens rea, the culpable mind that is required in any criminal case, right? That's so any criminal charge, right? You had the prosecutor has to prove not only that the defendant did the thing, but that they also had a culpable mental state in doing it. It wasn't just like low level negligence. It was at least recklessness or intentional or what have you, various standards based on depending on the charge. But what he's saying here is that Wood was trying to argue that that they couldn't possibly prove that she had the culpable mental state of impersonating a federal agent, but he's saying they wouldn't even need that for that particular charge, because all they would need to show is that she knows she's not a federal agent, which it would be insanely laughable for anyone to conclude that she thought that she was an FBI agent while writing it, assuming that you can show that she actually wrote it. So that's a good point here. What's more, neither Wood nor Gore even attempt to contest the forging was illegal under California law. The claimed protected activity is conclusively illegal under the first prong, even if Wood claims she did not do those acts under the second prong. All right. Yeah. I mean, that's actually a really good argument. All right. And then this is footnote 5. What do they say here? Even if Wood is somehow correct that her declaration makes the fake FBI letter protected activity as to Wood, it does not as to Gore. In any event, there also is evidence from which the jury may find Wood vicariously liable for Gore's conduct. Okay. Part C. There is good cause for limited discovery regarding the recruiting, coordinating, and pressuring of prospective accusers to lie about Warner. And actually, hang on, I've got some starred chats here. Uncivil Law, thanks so much for the super chat, says, watch me now purposefully misinterpret your comment for lulz. Here we go. Mr. Bites bought you a breakup sweater on your honeymoon? Wow, what a turn. No, it wasn't a breakup. It was not, is not, and never will be a breakup sweater. Andy the Game Maker says, not that much. Keep it in your pants. I said almost as much as I love him. Queen Bee Missy says, question, didn't she say, I thought the letter was real when she got it and has no reason to not believe it? Yes, but that doesn't necessarily mean just because she says that that's the case, it doesn't necessarily mean that that is in fact the case. So, like I said before, my example of somebody saying that they didn't run a red light, when you can produce a witness of somebody who was standing there at the intersection or sitting in their car at the intersection and saw the red light, saw the person drive through the intersection when their light was red. Yeah, so you can disprove that even though the defendant there is saying, I didn't do X or I did do Y. So yeah, so she did say that. That was my understanding, at least in the motion and the memorandum of points and authorities. But like I said, I don't know if that was in the declaration as well. I don't remember anyway. 2012 Jameson. Thanks so much for another super chat. Says AH got caught on republication discovery. Important. Yeah. Yeah. Okay. 2012 Jameson says, would turning in fake letter to court be republication, not protected by litigation privilege? Fraud on court, also not protected. Yes. Yes, that's why I'm saying the use of that letter in other contexts outside of litigation is what would open her up to liability. For example, using that to try to recruit other women for a fraudulent smear campaign against Brian Warner. That would be an example of where it's not protected conduct. Fraud on court, also not protected, and that's what the criminal analysis here that we just went through, that's what that was getting at. Okay. All right. There's good cause for limited discovery regarding the recruiting, coordinating, and pressuring of prospective accusers to lie about Warner. Wood's argument that Warner should not get discovery because he has no admissible evidence that she, Wood, pressured people to lie about Warner is incorrect. Wood again disregards the relevant legal standard, citing Comstock, which said courts must accept as true all evidence favorable to the plaintiff, and citing to Sweetwater, which says courts do not weigh evidence or resolve conflicting factual claims. Wood's self-serving testimony that I have never pressured anyone to make false accusations against Mr. Warner cannot supplant the evidence and inference drawn from it to the contrary. Citing to the Skya Declaration Exhibit A, stating they told me to lie and act. Balog's Declaration Exhibit A, reference joining Wood. King's Declaration referencing joining Wood. Kump's Declaration filed with a Wood motion. And the Exhibit 9 stating accusers had no memory of abuse until attending Wood's group. You can if there are enough breadcrumbs there, the inferences are supposed to be read in favor of the plaintiff at this stage in the litigation. But even if it could, Wood's denial is not coextensive with the conduct alleged to be outrageous, i.e., recruiting, coordinating, and pressuring multiple women to make false accusations against Warner. Wood also urges, footnote 6, whether or not the claim proceeds against Gore only, there is ample evidence of vicarious liability for Wood as Gore's principal or co-conspirator. See, for example, Balog's Exhibit A, Gore recruiting email regarding meeting with Wood sent from Phoenix Act account, King's Declaration, Exhibit C, which says Gore recruiting message referring to Wood in the Phoenix Act, and then Exhibit A at 5, Wood, I am the founder of the Phoenix Act. And then Brighton Gore's declaration, where it says Gore working for Phoenix Act to make money. King's Declaration, Exhibit A, Wood sent fake FBI letter with Gore's and Wood's names on it. And 2, the requested discovery is still relevant and necessary to defeating Gore's motion. So basically what he's saying with this footnote is, so there are enough breadcrumbs here to put together an argument that a jury could find that because Gore is sending these emails from the Phoenix Act email account. She is referencing the Phoenix Act in reaching out to these women. The FBI letter is addressed to her and to Evan Rachel Wood. Evan Rachel Wood said that she is the founder of the Phoenix Act. And also in his complaint, he says that she's the only person in charge of it, right? She's I guess like the CEO or whatever of the Phoenix Act, the corporation. So I mean, if Gore says that she is acting on behalf of the Phoenix Act, and the Phoenix Act is essentially a representation of Evan Rachel Wood, yeah, there's enough there that a jury could say, yeah, she's working to the benefit of Evan Rachel Wood. And then his second argument is that even if a jury couldn't put those breadcrumbs together and make that kind of a conclusion that the discovery that's requested is still relevant and necessary to defeating Gore's motion, even if you can't attribute it to Evan Rachel Wood, it's still completely relevant and necessary for the accusations against Gore, because she's a party here too. And that makes perfect sense. So far in this reply, I'm pretty tuned into all of these arguments. Wood also urges the court to err by assessing credibility and accepting her interpretations of the evidence, citing to Gruber, which says courts must accept the non-moving party's evidence as true and not weigh the credibility or comparative probative strength of competing evidence. Given that Warner has denied the accusations of abuse, whether or not it was outrageous to recruit, coordinate, and pressure women to say he did is, at worst, a question for another day. Citing to Plotnick v. My House, which says rejecting argument that conduct was not outrageous as a matter of law, where the jury could reasonably conclude the defendant's words and actions combined did not constitute mere violations of the niceties of polite conversation. So yeah, if there's a scintilla of evidence, right? A chinchilla of evidence, as I like to say, there's any way that a jury could find in a particular way, they're not going to take that question away from them by dismissing the action or dismissing the claim. Wood also fails to establish that a single piece of evidence, Exhibit A to the Skya Declaration, contains inadmissible hearsay of accuser Ashley Morgan Smithline and may not be considered because there is no indication that plaintiff will be able to cure. Miss Smithline, here's a bit of spice for you guys. Miss Smithline will be deposed under oath before Warner's oppositions are due in the action filed against Warner by Esme Bianco. That sworn testimony can be submitted here. In the instant case, had the reporters, and it's citing DeSantis, which says, in the instant case, had the reporters testified to those facts under oath in another proceeding, that evidence would be made by competent witnesses with personal knowledge of the facts they swear to be true. Moreover, Wood offers no authority to support the argument that Evidence Code Section 356, which makes additional portions of a writing admissible when a part thereof is given in evidence, makes the excerpts offered by Warner inadmissible without the entire conversation, nor could it here. So 2 parts here to this paragraph. So number one, that bit of spice right here, saying that this was one of the questions, right, that came up with the DMs that were submitted as part of Skya's declaration was why. So Warner is asking to depose 5 witnesses, including 3 third parties. Why wouldn't Ashley Morgan Smithline be one of them? Well, this is exactly why, because Warner's already in litigation with Esme Bianco because she has sued him because of her allegations against him for similar reasons, DV stuff. And so he's going to be able to get a deposition. Well, they have it. It's scheduled. It's on the record. It's scheduled. And so they will be deposing Ashley Morgan Smithline already. And that they're able to use that deposition, the substance of that deposition in this particular case, because they're similar enough, right? They come from like a similar sort of universe of facts. And so because of the fact that they are already deposing her elsewhere, that means that number one, they don't need to depose her in this particular action, at least not yet. And the thing that they would want to be deposing her in this action for this particular issue for anti-SLAPP, they can ask her in that other deposition. So number one, they're already doing it. Number two, they are making it so it makes it easier, right? Because they're already entitled to that discovery. They don't have to ask for that. They're entitled to it. And in this particular case, they're able to focus on these other depositions that they are requesting, these other 5, right? Because like I said before, when a plaintiff is filing a motion like this that is requesting limited discovery under the specter of an anti-SLAPP motion, you want to be very precise about the kind of discovery that you're requesting, because you're only allowed to request information that is necessary to meet your burden to oppose the anti-SLAPP motion. You can't be requesting all kinds of other discovery for the rest of the case, right? Like that's discovery for another day. This particular issue is much more narrow. So this way, they're saying, look, we're already deposing her. We don't need to add her to this list of 5 because number one, we're entitled to it over there. We don't have to narrow down the deposition. And number two, then like we're being that much more precise. We're being that much more narrow focused on what we're asking for here, which also makes it a bit more likely that that he could possibly win on this motion, because he's cutting out the fat. He's cutting out the stuff that he doesn't need to request. So okay. Anyway. Okay, so then oh, and then the other part about this here is that the other argument that Evan Rachel Wood made about the text messages, right? About the DMs was that she said in her opposition, well, there's the rule of completeness. And so, these are just portions of the DM thread that were that are included here in that declaration. There's probably more that's needed for context. And so therefore we should keep everything out. And what I said was, that's not the remedy for a completeness issue when it comes to admitting certain pieces of evidence. If you say, hey, look, they're only like they've taken evidence out of context, right? They've taken a particular document, they've taken pieces of a document and put it out of context. Therefore, it's not admissible. The court's going to say, no, you can introduce the rest of it to contextualize it for the jury. So that's usually the remedy. And that's what they're saying here. Part D. Warner has established good cause for limited discovery regarding the falsehoods about Groupie. Wood does not dispute Warner can make a prima facie case of defamation in IIED against Gore. Wood's arguments boil down to the contention that Warner is not entitled to discovery because she, Wood, did not make the defamatory statements. But even if Wood was somehow removed, she cannot explain why discovery that is relevant and necessary to those same claims against Gore should be denied. Warner does not seek Wood's deposition on groupie topics, so it is not clear what her issue is. What's your problem, Evan Rachel Wood, is what they're saying. That said, Wood does have liability for the defamation and IIED claims, even if only Gore uttered the defamatory statements, which Gore does not dispute uttering. Wood does not need to have made the statement herself to be liable for it. She can be vicariously liable as Gore's principal or as Gore's co-conspirator. But contrary to Wood's argument that discovery should be denied because the complaint fails to state a cause of action based on civil conspiracy, there is no cause of action for civil conspiracy which to state. Citing to Spencer, which they say says conspiracy is doctrine of liability and not a cause of action itself. Rather, the doctrine is one of vicarious liability. Each member of the conspiracy becomes liable for all acts done by others pursuant to the conspiracy. This is true. But I still think that this is Warner's weakest part of the complaint. Regardless, the complaint more than sufficiently alleges a conspiracy by Wood and Gore to publicly cast Warner as a rapist and abuser, a malicious falsehood that has derailed Warner's successful music, TV, and film career, in furtherance of which Gore and Wood committed numerous wrongful and illegal acts. The complaint alleges each of 1, the formation of a group of 2 or more persons who agreed to a common plan or design to commit a tortious act, 2, a wrongful act committed pursuant to the agreement, and 3, resulting damages. Wood fails to appreciate that a conspiracy's existence is often inferentially and circumstantially derived from the character of the acts done, the relations of the parties, and other facts and circumstances suggestive of concerted action. Yeah. And then they cite to Spencer again, which says that the agreement may be express or tacit. Gore's defamation of Warner was within the ambit of the conspiracy, and thus Wood may be liable. CEG complaint, paragraph 71, the false and defamatory statements would validate and enhance or fabricated narrative regarding Warner's alleged abuse of others. And then it cites it points to footnote 8, which says Paula Weiss was 21 years old at the time she acted in Groupie. Wood's claim that testimony cannot be admitted without Warner admitting the film itself under the secondary evidence rule is not only farcical, but also inconsistent with Wood's claim elsewhere that someone saw the film and thought the actress looked underage. In any event, Wood cannot rely on inadmissible hearsay statements she claims were made by Warner's former manager, aside from there being no evidence the former manager actually said these things. He did not. The language Wood relies on says nothing about the actress's age and thus does not actually support her argument. And also footnote 7 here, I skipped over, where they cited to the Hawley Declaration, which Wood describes as reports having surfaced online in which Smithline denies making the statements attributed to her, does not even refer to Sky Exhibit A. It also reflects double hearsay and is at most offered for the court to improperly weigh. Okay. Referring to the Smithline situation. Okay. Oh, and then this is the end of the motion. I was expecting at least a conclusion paragraph, but I guess maybe they were in a rush, perhaps. So, okay. Well, I think that's a pretty decent reply here. So far, like I said before, the arguments here were about what I would expect, and I agreed with basically everything that they were saying here. I really didn't find, other than, like I said before, the weakness of what I see as weakness of the groupie claims as to Evan Rachel Wood. They might squeak by on that one, but it would have been better if they had like made 1 or 2 more sentences about Evan Rachel Wood's involvement in those statements. But anyhow, all right, let's get to the response to defendant Gore's purported objections to evidence. All right. And before we do that, we have one question here. Queen Bee Missy says, question, when this goes to trial, since he's claiming IIED, is he open to psych exams from both sides? Well, his allegations, I don't think so. I don't think so. Well, maybe. He might be. Like he hasn't, if I remember correctly from the complaint, he didn't allege anything specific like PTSD or anything along those particular lines. So that's why Amber Heard famously was subject to an independent medical examination. Excuse me. So because she had claimed that she was suffering from PTSD. And so when you make a very specific claim like that, you open the door for the other side to say, okay, I need to be able to poke and prod that to see if, do you really have PTSD? We can't just take your allegation at face value. So if he he definitely is going to be subject to a deposition where they will ask him about his mental state, his emotional health, and the things that he's been going through. So he will definitely 100% be asked whether or not he will be subject to an independent medical examination. I actually am not entirely sure. I have litigated cases in California that included, I was on the plaintiff side, included IIED claims on the plaintiff's behalf. And I have never done an independent medical examination or evaluation of my client. None of my clients have ever been subject to that in California. And that was like fairly routine in our practice to add IIED claims to the particular causes of action that we were alleging in certain cases. So I would say I don't know. I'm gonna look into it to see what exactly is necessary in California for an IME. But I would say the best answer that I can give right now is maybe. um Oh, Wynn says, didn't he say depression or was it just meant as feeling depressed and not diagnosed as depression? I'm not sure though. I don't remember there being any actual psychological like diagnoses being alleged, but I could be wrong. I could be wrong about that. Um Couple more questions here. Christine B. Anderson says, a question, do you think they will bring up the fact that she has already shut down the Phoenix Act Foundation? She did in February 2022. If the cause was so important, they might. They might. I mean, it might just be part of, um, I don't know. I, at the very least in discovery, they will be getting into that. They will be asking her in deposition. Not necessarily. So assuming that the court allows anti-SLAPP discovery to happen, they won't be asking her about it at that stage. But if the litigation proceeds further, they'll for sure be able to ask her all about the Phoenix Act, because it's been pretty centrally relevant to this entire case, at the very least for context. So for purposes of discovery, yes, they will be able to ask her about that. But at trial, it depends on like what they get out of those conversations at deposition, if that makes sense. Dominica says, question, Andrew Burkhart found a filing from ERW asking for the Phoenix Act to be dismantled as a nonprofit. The social media of the Phoenix Act are also dead since last summer. I wonder what that means. Yeah, from what I have heard, I haven't independently verified, but I have heard that the Phoenix Act has been dismantled. So that could be the case, and that would be why everything else is shut down. Okay. Alrighty. Let's get back to this motion. But first, one more super chat. SD, thanks so much for the super chat. Very generous of you. Thanks for covering this case. Thank you. Well, thank you. Oh, and Manson cases says the Gmail is gone too, but the website is up again in recent months. Weird. That is weird. That is very strange. Huh. Okay. Drizzy, good morning, y'all. Does anyone know when the trial begins? So the action was filed March 2nd, 2022. Default in California for civil cases usually is going to be that they try to set the trial a year out. But my understanding is that, the California courts are backed up since, I mean, they kind of were backed up even like a couple of years ago when I was last litigating in California specifically. And so since COVID, I would imagine that they're even worse. So I've got to take a look at the docket again to see if they have a court date set, but they probably do. They usually do. That's usually one of the first things that happens. And then they can always push that back if necessary, because they're saying that the discovery process is taking too long or what have you. So 2012 Jameson says, hit me up on the IME stuff. I get that all the time. Okay. Yeah, for sure. We'll do. Yeah, I can also do independent research too. because I'm thinking specifically for California. And I know you are in Texas. Okay. Response to defendant Gore's purported objections to evidence. Alrighty. And they're going to go through all the declarations from the discovery motion. Plaintiff Brian Warner respectfully submits this response to defendant Ashley Gore, aka Illma Gore's purported objections to evidence submitted with Warner's motion for limited discovery pursuant to Code of Civil Procedure, Section 425.16G, motion. Okay. Part 1, Introduction. The objections appear intended solely to harass and burden Warner during the limited time he had to prepare replies to the lengthy oppositions of Gore and defendant Evan Rachel Wood. It is unclear how the vast majority of Gore's litany of objections could have been made in good faith. Gore contends that the entirety of most of the declarations and exhibits submitted by Warner are irrelevant. The declarations and the exhibits attached here too go to subjects that Wood and Gore, by filing anti-SLAPP motions, put at issue, i.e., by demanding that Warner make a prima facie showing on every element of the challenged causes of action. Gore knows this because she argued Warner could not make the following. Oh, sorry. Let me read that again. Gore knows this because she argued Warner could not make that showing, and thus declarations are cited throughout the motion to rebut this. Adding insult to injury. So now we're getting a little salty. Adding insult to injury, Gore's objections provide no explanation for why she contends these plainly relevant topics are irrelevant. Based on her and Wood's submissions to date, it appears Gore contends that much of the evidence is irrelevant because, she argues, her interpretations thereof are more correct. But that is inappropriate at this stage, citing to Gruber v. Gruber, which says, because a court is to accept the non-moving party's evidence as true, the court is not to weigh the credibility or comparative probative strength of competing evidence. Okay, so in other words, what he's saying so far is Illma Gore objected to all of the declarations that Brian Warner included with his discovery motion, right? The Skya motion, the Brighton Gore's motion, Polo Weiss's not motion, declarations, I should say. So all of these declarations that were signed under penalty of perjury, and went through and made tons of factual claims. Illma Gore was saying that all of those, basically all or most of them, were irrelevant. And so his point is, they were all responding to points that were brought up in her anti-SLAPP motion or in Wood's anti-SLAPP motion, or both. There is also no basis for Gore's innumerable hearsay and foundation objections, given that Warner filed the motion so he may collect by deposition admissible evidence of facts he already knows about. And then it cites to Sanchez v. Bezos, which says, notwithstanding the discovery stay, the court has discretion to order upon good cause specified discovery if required to overcome the hurdle of potential inadmissibility. The repeated hearsay objections to defendant's own statements are meritless, but she makes them anyway. The purported objections should be overruled in their entirety, not only because they fail individually, but also because as a whole, they are baseless and oppressive. Citing to Cole v. Town of Los Gatos, which says, where a fair sample of objections appear to be meritless, the court can properly overrule all of the objections on the ground that they constitute oppression of the opposing party and an imposition on the resources of the court. So basically, they're saying all of the objections that Illma Gore had in her opposition individually fail, and we'll go through them individually, but also she added so much that was just intended to slow down this whole process and put pressure on Brian Warner's case, on his ability to respond, because he's under a very short deadline to reply to the oppositions. Like I said at the beginning of this live stream, they've only got 5 days to respond after the opposition was filed. So he's basically making that argument. I would say their first argument about the individual objections is stronger than their second one because generally speaking, uh, my understanding is that when you are going to like get rid of all of the objections to something like that, it's because like oppression with those with the sheer volume of objections, sheer number of objections on a thing, the standard of oppression is pretty high, right? It has to be like generally speaking like paragraphs of just like blocks of objections one after another that basically makes it like pretty much impossible for them to get their reply in time because they have to go through every single one of those. So yeah. So anyway, so I don't think that we're there in this particular case because they're talking about what's the first one was relevance, and then we're talking about hearsay and foundation, which are basic, pretty basic objections, but they're not. There are many, many, many more objections that could have been added that would have made it oppressive. Part 2, the court should overrule Gore's purported objections. A plaintiff need not satisfy all preconditions to admissibility at the time of the anti-SLAPP hearing, but instead must demonstrate it is reasonably possible the evidence will be admissible at trial. Gore cannot establish that any of the objected to evidence will be inadmissible at the anti-SLAPP hearing, let alone at trial. All right, starting with the declaration of Dominic Skaya. Objection 1. This exhibit comprises excerpts of an Instagram conversation between Dominic Skaya, the declarant, and the Instagram account Ashley Morgan Smithline, as explained in the declaration. Another declarant that this account was used by Ashley Morgan. Oh, another declarant explains that this account was used by Ashley Morgan Smithline. Smithline is a co-conspirator of Gore and Wood and has made false accusations of abuse against Warner. Gore contends the exhibit lacks foundation and is hearsay. There is no issue with foundation. Skaya declares only that the exhibit is an excerpt of a conversation he had with the Instagram account Ashley Morgan Smithline. As to hearsay, the purported evidentiary defect can be cured, and thus it would be premature to sustain Gore's objection now. Citing to Sanchez, which says plaintiff may overcome the hurdle of potential inadmissibility with additional evidence. And this is true. So far, I'm tracking here. Here, Smithline is independently scheduled to be deposed on August 17th, 2022, as a non-party witness in Esme Bianco v. Brian Warner, aka Marilyn Manson et al. The Instagram messages, which also discuss Bianco, are relevant to that action as well. Because her deposition testimony will be under oath, it can be used here to cure any purported defects. Damn, Daniel. And then it cites to Sanchez saying, in the instant case, had the reporters testified to those facts under oath, this was cited and quoted in the last motion or in the last reply too. In the instant case, had the reporters testified to those facts under oath in another proceeding, that evidence would be made by competent witnesses with personal knowledge of the facts they swear to be true. And to be clear, what does this mean right here? This last portion right here. This is evidence that is made by competent witnesses with personal knowledge of the facts they swear to be true. This looks like it's referring to an exception to hearsay. So when we're talking about hearsay, if you're not familiar, hearsay is an out-of-court statement that is offered to prove the truth of the matter asserted. In other words, the out-of-court part is easy, right? Somebody is walking down the street and they say something that's out of court. It's not in a deposition. It's not, not under oath, right? Not in court. Or I guess technically a deposition is also out of court. But anyway, it's not made in court in front of a jury, etc. Then the rest of the definition for hearsay, out of court statement, offered to prove the truth of the matter asserted. In other words, it's where somebody says, so-and-so did this. An example would be Amber Heard telling Rocky, Johnny punched me. if they try to offer that in trial as a statement that, from Rocky saying, Rocky had a conversation with Amber Heard. And then the question is, Rocky, what did Amber say? Amber said, Johnny punched me. If they are offering it to prove that Johnny actually punched her, that's not admissible because that is hearsay. But if they are offering it for some other reason to rebut that he had said something else or something along those lines, I don't know. I can't think of other purposes for that particular statement at the moment. But that would be if they were offering it for some other purpose, then that is like to impeach someone. You can offer a statement as an impeachment, as an example. That would be permissible to bring that into court. But otherwise, that sounds like they're just saying Amber said Johnny punched me, therefore Johnny punched me. That's not possible. That's not admissible. That is the definition of hearsay. But here, what they're referring to here by evidence that would be made by competent witnesses with personal knowledge of the facts they swear to be true. This is one of the things that could possibly come up here, is that those DMs were also statements against her interest. So that kind of language there seems like it's getting to the requirements that we went over in the last live stream about statements against interest. Okay. Part B, declaration of Jaden Elworthy. Elworthy states under oath that after spending time with Smithline in person, she later contacted me on Instagram Messenger from the account Ashley Morgan Smithline to communicate about this time, which confirmed to me that this account and the person I met were the same. Gore argues this testimony is irrelevant because, according to Gore, to the extent the Elworthy declaration is offered to authenticate the messages attached to the Sky Declaration, and there's another passive aggressive sick. It is inadmissible. It is inadmissible for this purpose. Gore offers no authority for this objection. Evidence Code Section 210 states that relevant evidence means evidence including evidence relevant to the credibility of a witness or hearsay declarant, having any tendency in reason to prove or disprove any disputed fact that is of consequence to the determination of the action. In other words, it can go towards proving or disproving a witness's credibility. That is kind of like an underpinning fact for the testimony that they're going to give that would be speaking to the actual causes of action. Elworthy's testimony has at least any tendency to prove that the account Ashley Morgan Smithline belonged to Smithline. This is apparently a disputed fact, given that Wood contends that Smithline denies making the statements attributed to her. And, for example, whether Smithline was told to lie and act by Wood and Gore is of consequence to the determination of the action. Absolutely. Part C, declaration of Esme Balog. Balog's declaration described how she was recruited to participate in a group put on by Wood, Gore, and the Phoenix Act, a domestic violence survivors organization. And then it cites to footnote here. Whoops. Oh, shoot. Hang on. Oh, okay. It just opened a new tab. Oh, the phoenixact.com is actually, it's working. I didn't mean to click on the link there. I thought I was just going to be highlighting it. Anyway, it does open up another tab and takes you right to their website. Okay, anyway. Where was I? Where is footnote 1 here? Okay. Balog's declaration described how she was recruited to participate in a group put on by Wood, Gore, and the Phoenix Act, a domestic violence survivors organization, where people would talk about experiences they had that might be similar to Balog's. However, as Balog explained, she did not have any such experience to talk about, as her interaction with Warner, which was being mischaracterized by Wood's and Gore's co-conspirator Ashley Walters, was consensual. Unlike Balog, others could not resist Gore and would go on after meeting them to make false accusations against Warner. Gore's contention that the declaration is irrelevant again misunderstands what is relevant under the evidence code and also misapplies the standard under which the court considers this evidence. The court does not weigh evidence or resolve conflicting factual claims. Instead, the court must accept as true all evidence favorable to the plaintiff and assess the defendant's evidence only to determine if it defeats the plaintiff's submission as a matter of law. Gore urges the court to violate these rules not only by accepting her interpretations of the evidence instead of Warner's, but also by excluding the evidence entirely. There is no basis to do so. I said it before, I'll say it again. Any gray areas, any muddy middles at this stage in the litigation go to favor the plaintiff. Objection 4. Gore objects to a portion of paragraph 8, which states, I was being recruited by Gore as a supposed victim of Warner on the grounds that it lacks foundation and is improper lay opinion. While Gore fails to provide any basis for these objections, the declaration lays adequate foundation. Balog explains that she received emails from Gore and attaches the emails to the declaration. Balog explains her experience receiving those emails and why she did not join Gore and Wood's group. She also explains that her story was later mischaracterized by Walters, further illuminating what Gore thought Balog may say she had participated. Gore's improper lay opinion objection fails for the same reasons, as paragraph 8 contains permissible testimony that is rationally based on the perception of the witness and helpful to a clear understanding of her testimony. It is not expert testimony. Part D, Declaration of Paula M. Weiss. Going to objection 5. Weiss was the actress in Warner's film Groupie. Gore purports to object to Weiss's testimony that any statements that I was under the age of 18 at the time Groupie was filmed, that Groupie depicted or constituted child illicit material or abuse, or that I was dead or killed are unequivocally false. I am not writing this from beyond the grave, is what she said. I mean, she didn't actually say that, but essentially. I'm paraphrasing. Contrary to Gore's objection, the testimony is plainly relevant to Warner's claim that Gore and Wood defamed him by stating that Groupie was child illicit material. It establishes falsity of the statement. Weiss states elsewhere that in her testimony that she was at least 21 years old during filming. Thus, it was not child illicit material or abuse. Accordingly, Gore's objection that this constitutes improper lay testimony as to whether the film depicted abuse is misplaced. The Section 800 objection also fails because the testimony is rationally based on the perception of the witness and helpful to a clear understanding of her testimony. She explains her role in developing and acting in the film and that she considered it a professional project. Fair enough. Part E, Declaration of Blair Burke. Objection 6. Gore purports to object to the entire declaration as irrelevant. The declaration explains that Burke, counsel to Warner, spoke to the FBI agent whose name was listed on the fake FBI letter, Michelle Langer, and that Agent Langer explained she did not draft, sign, or authorize the letter and never investigated Wood or Warner. The declaration also explains how Gore and her Phoenix Act co-conspirators became aware of Langer. Footnote 2. Exhibits A, B, and C provide further context about co-conspirators Mitch Emerson and Kelly Blousechild. Burke explains how she obtained these documents. Gore cannot in good faith dispute the fact that these individuals are affiliated with the Phoenix Act alongside Wood and Gore, or that Kelly Blousechild also goes by the name Kelly Blouse, and Gore hasn't. To the extent the court is inclined to sustain Gore's objections as to the exhibits, Warner will seek judicial notice of these indisputable facts in his opposition to the motions to strike. Okay, now coming back to this paragraph. These facts are plainly relevant to Warner's claim that the forging and improper use of the letter and fabricating an FBI investigation by Langer constituted outrageous conduct. It is hard to imagine how Gore made this objection in good faith, especially considering she has not even attempted to disclaim involvement in the forgery, and Wood has not disclaimed Gore's involvement in the forgery either. Yeah, we've got some salt here. It's hard to imagine it, they said. Gore's purported hearsay objection can be cured by the deposition of Agent Langer that Warner already requested in the motion. And then it cites to Sanchez, which says, stating, notwithstanding the discovery stay, the court has discretion to order upon good cause specified discovery if required to overcome the hurdle of potential inadmissibility. Objections 7, 8, 9, and 10. See response to objection 6. So basically, same. They're like, Your Honor, we're not going to make you read through that paragraph time and again. Just read it once and apply it to these other objections. Declaration of Brian Warner, Part F. But first, KM Cheesehead, thanks so much for your super chat, says, actress Paula Weiss-Martinez is deceased, but she is very obviously a different person and died before a groupie was made. Could they claim they were confused? Also, where did Wood get the FBI letter? Oh, Paula Weiss-Martinez. Oh, that's a different person is what you're saying. She died before a groupie was made. Yeah, I mean, well, one of the problems with the groupie cause of action is that I think it was in Brighton Gore's, let me do this. In Brighton Gore's declaration, she includes text messages from Illma Gore to other individuals talking about groupie. And one of those was saying where the statements where she says that the actress is dead. I think she says something along the lines of that actress was Jeanette. I think it was Jeanette or something like that, which to me would indicate that there's a good possibility that she believed that the actress was someone other than Paula Weiss. That is definitely a possibility. And I would fully expect Illma Gore to use that defense for the defamation cause of action. Because remember, Marilyn Manson is a public figure. And so Brian Warner is a public figure. And so he has to prove defamation, not just with negligence, but with actual malice. He has to prove that Illma Gore lied about Paula Weiss, her age and whether or not she was alive, that she lied, not just negligently, but she lied either knowing that what she was saying was false or being reckless as to the truth or falsity of that statement. So if she just says, hey, I had a reasonable belief that this was some other actress named Jeanette, that's not some other name for Paula Weiss, that is something that that could be a decent defense for her. Now, of course, Brian Warner could then, if there's evidence elsewhere of her saying, no, I know exactly who this person is, and this is exactly what happened to her, and who she's talking about is fairly clearly Paula Weiss, then that's, he could use that to combat that defense. But where did Wood get the FBI letter? You mean, where does she say that she got the FBI letter? She hasn't clarified that in any of her filings yet. So in her anti-SLAPP motion or in her opposition to the discovery motion, she hasn't said where she got the FBI letter. So I don't know if maybe she says somewhere in the Tennessee I think there was Tennessee and California. There were custody matters there where she used the FBI letter. I don't know if she says in any kind of a declaration in either of those cases, because I haven't looked as detailed into those filings as I have into these yet. But yeah, I don't know, but we'll find out what she claims as to where she got it. But thanks for the super chat. Okay. F, declaration of Brian Warner. Objection 11. Gore's objection to the entirety of Warner's declaration as irrelevant is frivolous. I mean, it's kind of laughable, to be honest. The declaration is cited throughout the motion, including in the section describing the evidence Warner has to make a prima facie showing on the elements of his claims in his forthcoming opposition to the motions to strike. It is hard to image, I think they're supposed to say imagine, how Gore could contend in good faith that evidence Warner intends to use to make his prima facie case is irrelevant. See Comstock site where they say the court must accept as true all evidence favorable to the plaintiff. Likewise, she is also wrong that the declaration is irrelevant to the issues presented by Gore's anti-SLAPP motion. By claiming in her motion to strike that two of Warner's claims arise from protected activity, she shifts the burden to Warner to show a probability of success on his claim, i.e., to make a prima facie showing on all elements of his claims. Here's another point of clarification. So it's also been asked, what does protected activity mean? Protected activity means activity or conduct that is protected under the Constitution. So we're talking about the conduct that Evan Rachel Wood and Illma Gore are trying to say is protected under the First Amendment, and therefore is not something that can give rise to liability under the anti-SLAPP statute. So whenever this phrase comes up, protected activity, we're talking about free speech rights. We're talking about petitioning rights, that kind of stuff. So, but yeah, his point here is that he's saying, look, by making the arguments that she did in her anti-SLAPP motion, she made all of this completely relevant to this particular controversy, this particular issue, because I have a right to respond to that. And he's correct. Gore also ignores that the declaration is relevant to opposing Wood's motions. So even if she were correct, which she is not, there is no basis for Gore to contend she can have the evidence stricken altogether. Objection 12. This paragraph concerns a woman who was improperly recruited by Gore and or Wood, and to whom Gore repeated the falsehood that Groupie depicted an underage girl as a recruiting tactic. Warner's counsel attempted, oh, hello. Hi, Holmesy. How are you? Do you have something to say? You just want to hang out with us? Okay. All right. Goodbye. Sorry, where was I? Okay. Warner's counsel attempted unsuccessfully to have evidence from this woman submitted via declaration. Thus, Warner's motion already seeks her deposition to obtain evidence admissible to oppose the anti-SLAPP motions, citing to Sanchez, which says, in the instant case, had the reporters testified to those facts under oath in another proceeding, that evidence would be made by competent witnesses with personal knowledge of the facts they swear to be true. The hearsay and foundation objections should be overruled accordingly. Gore's further objection that this evidence is irrelevant should also be overruled because she again misunderstands what is relevant under the evidence code and misapplies the standard under which the court considers the evidence. The court does not weigh evidence or resolve conflicting factual claims and must accept as true all evidence favorable to the plaintiff and assess the defendant's evidence only to determine if it defeats the plaintiff's submission as a matter of law. Throughout these objections, Gore urges the court to violate these rules not only by accepting her interpretations of the evidence instead of Warner's, but also by excluding the evidence entirely. There is no basis to do so. All right, objection 13. This paragraph includes quotes from Gore and Wood with citations in which they claim that Warner abuses children. Accordingly, there is no issue with foundation or hearsay. Statements by defendants Gore and Wood admitted against them are not inadmissible hearsay. And then it cites to Evidence Code Section 1220, which says evidence of a statement is not made inadmissible by the hearsay rule when offered against the declarant in an action to which he is a party in either his individual or representative capacity, regardless of whether the statement was made in his individual or representative capacity. In other words, you can this is called an opposing party's admission, a statement that is an admission by an opposing party. So to use it as an example, that's how pretty much all of the audio tapes came in during the Depp v. Heard trial, because The statements that were in those audio tapes that were very damaging to Amber Heard because she, admitted certain things, I didn't punch you, I hit you, or I didn't hit you, I punched you, or whatever, what have you. That's a statement. That's an opposing party admission, right? Even though that was Virginia, it wasn't California, so it's not the wording of the evidence code is probably a little bit different, but the concept is the same. Johnny Depp was able to introduce those statements that were against her own interest, that she was admitting to something. And likewise, Amber Heard was able to introduce evidence, statements by Johnny Depp where he was admitting to something. If it was, I don't know, any text messages where he's talking about doing drugs or doing, doing drugs, drinking alcohol, doing all kinds of different things that are maybe not so great. So those are opposing party admissions. This is the same thing. Nor are these statements irrelevant. Warner has pleaded defamation and IIED causes of action arising from the falsehood that Warner abused a child, which both Gore and Wood are seeking to have dismissed, including by Wood on the grounds that she did not make or conspire with Gore to make the defamatory statement. Gore, for her part, has put in no declaration disclaiming she made the statements at issue and ignores that Warner seeks prospective injunctive relief. That's a fair point. Rather, I mean, it's in her opposition, in Gore's opposition, what she said about the statements about the groupie video were that those were protected activity because they were statements about child illicit material, right? And that has been determined to be protected under the Constitution. Anyway, objection 14. Paragraphs 9 and 10 include testimony regarding the harm and emotional distress that Wood and Gore's conspiracy, as alleged, caused Warner. They should be read with paragraphs 8 and 11 and are cited in Warner's motion as evidence of his prima facie showing on the challenged claims. Given that harm and emotional distress are elements of Warner's claims, which Gore has specifically put at issue in her anti-SLAPP motion, it is unclear how Gore can contend in good faith that the testimony is irrelevant and should be stricken. Nor are there any foundation or lay opinion issues with Warner explaining how the conspiracy, as alleged, has affected him. Yeah, you can testify to how you feel in response to what somebody else has done. That doesn't require a lay opinion. That's just testifying to what you yourself have experienced. So yeah, all of this checks out so far. And then objection 15, see response to objection 6. Okay, part G, declaration of Brighton Gore. Here we go. Objection 16. Defendant Gore, referred to in this section as Illma, purportedly objects to the entire declaration of her twin sister, Brighton, and exhibits attached thereto on relevance grounds. Brighton explains that she, 1, witnessed Illma doctor a version of the fake FBI letter, 2, witnessed Illma discuss and send the FBI letter with /to Wood, 3, heard Wood make comments about the fake FBI letter to Illma, 4, found on an iPad previously used by Illma and linked to Illma's iCloud account, but gifted to Brighton by Illma, documents concerning Warner, including checklists, scripts, and the fake FBI letter, a document containing a version of the forged signature that appears on the FBI letter, and personal information about Warner. And 5, had a discussion with Wood about the fake FBI letter in which Wood acknowledged it was fake, but was concerned what would happen if that information became public. Whew, man, that's a damaging declaration, remember? If true, assuming that it's true. So, all of this is plainly relevant to Warner's IIED claim arising from the fake FBI letter and to defeating Wood's defenses to the claim, as explained in detail in the motion and Warner's reply to Wood's and Illma's oppositions filed herewith. Illma has not offered any sworn testimony denying any of the allegations against her, and Wood has not disclaimed Illma's involvement in Wood's sworn testimony. While Wood and Illma have attempted to provide competing interpretations of the evidence and have attempted to attack Brighton's credibility, none of this makes the evidence irrelevant. And in any event, none of their interpretations are due weight in ruling on Warner's forthcoming oppositions to the anti-SLAPP motions, citing to Gruber, which says because a court is to accept the non-moving party's evidence as true, the court is not to weigh the credibility or comparative probative strength of competing evidence. All good points. Okay. Objection 17. See response to objection 16, which addresses Illma's objection to the entire declaration, including paragraph 6. As to the additional hearsay objection, statements by Illma, a party admitted against her, are not inadmissible hearsay. It's true. The additional foundation objection is also baseless given that in paragraph 6, Brighton merely states what she saw and heard sitting next to Illma. Objection 18. See response to objection 16, which addresses Illma's objection to the entire declaration, including paragraphs 13 to 25. Paragraphs 13 to 23 describe the documents Brighton found on the iPad previously used by Illma and linked to Illma's iCloud account. Thus, there is no purported expert testimony or foundation issues, but to the extent the court is inclined to think there might be, the motion already seeks Illma's deposition to authenticate those documents. Citing to Sanchez v. Bezos, which says, notwithstanding the discovery stay, the court has discretion to order upon good cause specified discovery if required to overcome the hurdle of potential inadmissibility. Illma's interpretation of those documents do not manufacture a foundation issue, nor can there be any foundation or expert testimony issues in paragraphs 24 and 25, which merely recount what Wood told Gore in a conversation among them. So yeah, they're saying, so what Warner is saying here is that Gore was trying to argue, Illma Gore was trying to argue that Brighton's statements in a few of these paragraphs were improper lay opinion. In other words, it's where she's speculating to information that could only be testified to by an expert. But what they're saying here is no, she's stating what she saw, what she heard, what she felt. Those are all things with your five senses, which is something that any lay witness can testify to. Part H, Declaration of Howard E. King. Objection 19. Exhibit B is a printout from Gore's official Twitter account, which she concedes are her tweets. That's true. Citing to Gore's opposition, which says plaintiff cites a tweet by defendant Gore attached as Exhibit B to the King Declaration, which Gore writes, and then ellipses. So she does concede that she wrote those. The declaration explains how they were collected. There is no foundational issue or hearsay issue. Statements by Gore admitted against her are not inadmissible hearsay. Exhibits C and D are copies of communications with Gore. What Gore said is not inadmissible hearsay, and as Gore knows, the motion already seeks the depositions of the people with whom Gore was communicating to authenticate these communications and obtain evidence that can be admitted with Warner's oppositions to Gore's and Wood's motions to strike. Citing to Sanchez v. Bezos, which says, notwithstanding the discovery stay, the court has discretion to order upon good cause specified discovery if required to overcome the hurdle of potential inadmissibility. Conclusion. We are at the end of this one. Conclusion. For the foregoing reasons, Gore's purported objections should be overruled. So that one, again, I think that was another one that I've got some. I mean, I'm tracking their arguments. I don't really see anything that is jumping out at me that is a bad argument in my opinion. And I'm really trying to look for things to disagree with. Okay, now opposition to defendant Ashley Gore, aka Illma Gore's request for judicial notice. Alrighty. Okay. So remember, Illma Gore filed a request for judicial notice that basically is where a party says, hey, Your Honor, here's this fact that is not in dispute. We don't want anyone to spend any time arguing about it. We don't want the court to entertain anyone arguing about it. Let's just like nail this one down so no one has to argue about it moving forward. Basically, like the example that I gave last time was you could go to um, a certain date. Let's say you've got a murder case where the date on which the person died, there's an issue about how light or dark it was in order for someone to say that they saw something. So you could request judicial notice for the time at which the sun set or the sun rose on that particular day, so that no one can argue that. They're just like they nip that one in the bud early. So that's one example of a request for judicial notice that would be pretty standard. You can also file a request for judicial notice of another case that has been filed elsewhere that is, potentially relevant. So what happened here in Illma Gore's request for judicial notice was that she's requesting the court to take judicial notice of the existence of Brighton Gore's attempt to get a permanent restraining order against Illma Gore. Again, I don't know the specific facts of that particular issue, but I have seen the declarations and whatnot that were attached to the request for judicial notice. And what I said last time was that the court can take judicial notice of another case and the filings that were in there to say that certain filings were made, but the court cannot take judicial notice of the allegations that were made within those documents. So the declarations that were attached to the request for judicial notice here that were about Brighton Gore, about her relationship with Illma Gore, the court's not going to say, yeah, we're accepting all of those declarations as completely true if they grant the request for judicial notice, because they can't do that. That would be improper. Anyway, so what does Brian Warner have to say about the request for judicial notice having to do with Brighton Gore's her litigation, you could say, against Illma Gore? Plaintiff Brian Warner respectfully submits this opposition to defendant Ashley Gore, aka Illma Gore's request for judicial notice. Because exhibits A, B, and C to the Gore RJN are not relevant to the anti-SLAPP proceeding, and because Gore seeks judicial notice of the truth of the matters asserted therein, her request should be denied. Part 1, legal standard. Judicial notice may not be taken of any matter unless authorized or required by law. The Gore RJN relies on Section 452D only, which states judicial notice may be taken of records of 1, any court of the state, or 2, any court of record of the United States or of any state of the United States. The court is required to take judicial notice of records listed in Section 452 only if a party requests it and A, gives each adverse party sufficient notice of the request through the pleadings or otherwise to enable such adverse party to prepare to meet the request, and B, furnishes the court with sufficient information to enable it to take judicial notice of the matter. So in other words, they've got to give enough context for why they are requesting judicial notice of these other documents. However, the court may not take judicial notice of the truth asserted in court records. Exactly what I just said. As a further requirement, any matter to be judicially noticed must be relevant to the material issue. Part 2. The court cannot take judicial notice of exhibits A, B, and C. Brighton Gore is Illma Gore's twin sister. Warner submitted sworn testimony from Brighton with his motion. Brighton's declaration will be used by Warner to support his prima facie case and defeat Illma Wood's anti-SLAPP motions. Among other things, Brighton's declaration includes evidence that Illma had a significant role in forging the fake FBI letter at issue in Warner's IIED claim. Illma has provided no testimony or evidence disputing this fact, nor could she in light of Warner's evidence. Last year, a Santa Cruz Superior Court judge entered a temporary restraining order against Illma in favor of Brighton, but in June, he dissolved the TRO, the temporary restraining order, and declined to enter a permanent restraining order. The RJN exhibits are records from that proceeding, namely the court's order and various declarations. There can be no dispute these records are not relevant to a material issue in this anti-SLAPP proceeding. Gore argues the records are relevant to assess the credibility of Brighton Gore. However, in determining whether Warner has made a prima facie showing on the challenged claims, the court does not weigh evidence or resolve conflicting factual claims. Yeah, this is true. This is true. Because a court is to accept the non-moving party's evidence as true, the court is not to weigh the credibility or comparative probative strength of competing evidence. If the whole purpose of admitting Brighton Gore's of requesting judicial notice to include Brighton Gore's or these declarations about Brighton Gore, and they're saying that all of these things go to her credibility, those will probably be admissible at trial because that's an issue that creates a credibility issue for her at trial. The jury is 100% able to evaluate the credibility of every single witness that goes forward. So that would be relevant then. But for this particular issue, the anti-SLAPP issue, they are not weighing any of the evidence, determining whether certain facts are more likely than not. They're not looking at credibility of any of these witnesses that have made these declarations or that would be deposed here. They are not talking about any of that. That's not something that is part of the discussion or part of the analysis for an anti-SLAPP motion. So what they're saying here is that the request for judicial notice should be denied because it's not relevant to what is going on here. So far, this is really great. This is a really great argument. Citing to Gruber v. Gruber, and then also Boleyn v. Ryan Seacrest Productions, saying courts do not make credibility determinations or compare the weight of evidence when considering the pleadings and declarations. Absolutely true. Even if the court could assess Brighton's credibility now, it cannot. The RJN exhibits still have no tendency and reason to prove or disprove any disputed fact that is of consequence to the determination of the action. Because Gore does not dispute she participated in forging the fake FBI letter, she does not seek dismissal of that claim in her motion to strike and has not submitted any sworn testimony denying participation. For purposes of the anti-SLAPP proceedings, the RJN exhibits are not relevant. Yeah, no, I definitely agree with what they're saying here. Further, even to the extent the RJN exhibits could help assess the credibility of Brighton Gore, as Illma contends, the court would have to assume their contents to be true, which is improper. When considering court records under Section 452D, courts categorically refuse to take judicial notice of the truth asserted in court records, merely because they are in court records. That's also true. That's a very good point right here too. To say that like you can't just use these documents for her credibility. You would have to bring in these other individuals to basically counter testify against her. If this were a trial, that's what you would have to do. So I take back what I said earlier about this possibly being something that could be admitted later. When considering, oh, sorry, go ahead. I already passed this part. Okay. While courts are free to take judicial notice of the existence of each document in a court file, including the truth of results reached, they may not take judicial notice of the truth of hearsay statements in decisions on court files. Yeah. citing to Bach v. McNellis, which says lower court erred in judicially noticing the contents of an affidavit for the truth of the matters asserted. The existence of these records in the court's file has no independent relevance, and the Santa Cruz Court's order, Exhibit A, merely states that there was insufficient evidence to support issuance of a restraining order in this matter, having read and considered the record. There is no basis for the court to take judicial notice of the RJN exhibits. Gore's request should be denied. Damn. Do you agree? Hi, Indy Bear. How are you? I know you're hungry. I'll get you some food soon. Okay. So that is that one. That's pretty good. That's I totally agree. This request for judicial notice is probably going to be denied by the court, I think. Okay. Last one, guys. This is the last document. Declaration of Howard E. King in support of plaintiff's replies to defendants Wood and Gore's oppositions. And maybe I can finish this before Indy goes crazy for the food that she wants. You want dinner, don't you? Love you. Okay, just a little bit longer, okay? Okay. Declaration of Howard E. King in support of plaintiff's replies to defendants Wood and Gore's oppositions. No. Hang on. Okay. All right. So Howard E. King is an attorney representing Brian Warner, PKA Marilyn Manson. Okay. I also serve as counsel to Mr. Warner in the case captioned Esme Bianco v. Brian Warner et al. The Bianco action is one of the cases referenced in the declaration of Michael Crump, submitted with Evan Rachel Wood's special motion to strike. My office subpoenaed and noticed an August 17th, 2022 deposition of Ashley Morgan Smithline in the Bianco action after confirming the date with her counsel, who also represents Miss Bianco. The deposition will be recorded stenographically and by video. So in other words, this deposition will have occurred before this hearing, the day before this hearing, on this discovery motion is going to be done. It's going to be the day after this deposition. Okay. At the June 22nd, 2022 ex parte hearing, the court stated, referring to Warner's motion for limited discovery and request for continuance, if the motion is granted, we'll probably have to adjust those hearings on September 13th in order to allow the discovery to take place. A true and correct copy of the transcript from that hearing is attached as Exhibit F here too. If the motion is granted, Mr. Warner will have less than 2 weeks before his oppositions to the anti-SLAPP motions are due to serve subpoenas and take 5 depositions of mostly, if not all, out-of-state witnesses. So yeah, so in other words, this paragraph 3 right here is basically saying, Your Honor, you actually said that if you were going to grant this discovery motion, that you would have to move the rest of the hearings move the rest of the hearings back, right? Because so to remind you, if in case there's been a number of hearings that have been moving around, right? So initially there was a hearing on July 6th that was a case management conference. It's basically one of those like routine housekeeping hearings that happen periodically throughout the litigation to make sure that these cases progress, right? The judges, they want to make sure that these cases aren't just sitting, right? The lawyers are actually doing work on them. And so July 6th was one of the CMCs. And so the judge noticed that there were 2 anti-SLAPP motions on file and that the hearings were set all the way out in December and January, which is normally not ideal for an anti-SLAPP hearing. So the judge said, all right, we're going to move that up to August 18th. And so Brian Warner's attorney said, Your Honor, we don't want that. That's a little too soon. We needed some extra time to request some discovery, et cetera, et cetera. And so that's why there was an ex parte application, so that in between the July 6th hearing and the August 18th hearing, where the judge put one of the new anti-SLAPP motions on August 18th and then September 13th. Those are the 2 hearings that were set on the calendar. Those are set that the judge was saying those will be the new anti-SLAPP hearings. So in between July 6th, and then August 18th, like a week or 2 weeks later or what have you, Warner's attorneys requested an ex parte hearing where they said, we need an emergency hearing in front of the judge because this is an issue that if we try to go through the normal channels to request another hearing, it's going to be way after this next one and we'll be prejudiced in all kinds of terrible ways. So anyway, so that's why they had the ex parte hearing and they pushed all this kind of stuff back. So basically what the judge ended up deciding was, okay, August 18th is now the discovery motion hearing date. We're keeping August 18th, we're keeping September 13th, but we're changing the character of those hearings. So discovery motion hearing on the 18th, on August 18th, September 13th is now the first both anti-SLAPP motions will be heard on September 13th. And as I suspected, the judge actually said in the hearing, in the ex parte hearing, that, well, if we grant the discovery motion, you need enough time to request the discovery, to schedule all of that, and then to file your opposition to the anti-SLAPP motions. So we would be pushing. So if I grant the discovery motion, we would at that point push off the September 13th hearing. But for right now, it's on the calendar just in case I decide to deny it. This is completely normal discourse between the judge and the attorneys in scheduling all of these hearings and whatnot. And so they attached the transcript here to it. And this is where you can see, maybe I can just zoom in here where the judge actually says here. Can I zoom in more? There we go. If the motion's granted, they're both going to have to be moved, but they're entitled to have their motion heard. Whether it's granted or not is another story, but that's a problem otherwise. And then I think it was actually down here somewhere. Yeah, the court says if the motion's denied, then it will go forward on that date. If the motion's granted, we'll probably have to adjust those in order to allow the discovery to take place. So that is basically what he's saying here in this declaration is, hey, Your Honor, remember when we had that conversation? Well, here's the transcript from the court reporter that we hired for that particular ex parte hearing. And this is what they said, and this is what you said. So anyway, just talking about requesting to move stuff. Anyway, that for me is about it. 2.5 hours later. I hope you guys enjoyed this. I hope that you guys found this instructive, informative. I hope that it was that you were able to understand what we were going through and how I was explaining some of these things. And that you're able to understand the process a little bit better. But in my opinion, my thoughts coming at the end of this, I think that this motion is going to be granted. Whether or not she grants it as to the depositions of Evan Rachel Wood and Illma Gore, maybe not. I'm starting to lean more after the oppositions. I was thinking maybe she wouldn't grant it as to those two, but after the reply, I'm thinking maybe she will grant it as to them because Warner's saying that, this is just limited to authenticating documents that are necessary, and then like certain like particular questions that they have, like very specific questions that they have. Hi, what's that puppy? What's that doggo? So anyway, I'm thinking that the court is, at the very least, the court is likely to grant the discovery motion as to the third parties for sure. In my opinion, the other two, I'm at about 65% likelihood, yes, granting it for the other two depositions. So anyway, other than that, we'll see how it goes. We've got the hearing now. The next thing on this particular issue is the hearing that's on the 18th. It's 6 days from now. So we'll see what results from that hearing. But what do you guys think? Do you think that there is a likelihood of Manson winning on this motion, or maybe not? Let us know in the chat. Let us know in the comments below. Otherwise, thank you guys for having wonderful discussion in the chat, for being here. We've got a lot of folks that have been hanging out for this, and thank you to the mods, all the mods, for again marshaling great discussion. I always appreciate it. You guys do such great work, and I love having you guys here. Otherwise, what do you think, Indy? Huh? You just want food. Okay. Otherwise, for me, that about does it. Have a great weekend. I hope you guys had a great week this week, and have a great weekend. And I will see you guys probably on Monday. All right.